Hi friends, today we'll talk about section 12A of Insolvency and Bankruptcy Code. You see, sometimes what may happen is that a financial creditor or operational creditor for that matter has filed an application under section 7, 9 or 10 before the adjudicating authority and the application has been admitted. Subsequently, say due to any settlement reached between the applicant and the corporate debtor, or there could be some other reasons, this applicant decides that he wants to withdraw the application. Section 12A provides that application which has otherwise been admitted by the adjudicating authority may be withdrawn under section 12A. However, there are certain requirements. Like the requirements are in two parts. First part talks about a scenario where COC is yet to be formed, and second one is where COC has already been formed. In case where COC is yet to be formed, the applicant may file the application with the adjudicating authority through IRP. And in second scenario where COC has already been constituted, the application has to be filed through again IRP or RP with the approval of COC to the adjudicating authority for withdrawal of application. Here most important requirement is that the approval of COC has to be with the 90% of the voting rights. So this is most important requirement. In a recent case which has been eventually decided by Honorable Supreme Court, there is a developer based in Gurgaon, and there has been inordinate delay and completion of the project and handing over possession of the flats to the home buyers. In this particular case, there were 3 home buyers who had filed an application under section 7 before NCL 80, and their application was admitted. Aggrieved by the decision of this NCLT to admit the application, corporate debtor who filed an appeal before NCLAT. NCLAT also dismissed the application of the petition of corporate debtors. So eventually matter landed before Honorable Supreme Court. And at the same time, parallelly, efforts were on to reach to a settlement between home buyers and corporate debtors. As a result, there was inordinate delay and publication of this public announcement, and also in constitution of COC. Immediately after constitution of COC, even this first COC meeting was to take place. In the meantime, before a meeting could take place of COC, Supreme Court stayed CIRP. So as a result, COC meeting could not, even first meeting meeting could not take place. In this particular case, the interesting feature is like there were 128, 182 home buyers, and out of 182 buyers, three original applicants who were home buyers, they along with around 79 other home buyers reached to an agreement with the builder, and this agreement was submitted before Honorable Supreme Court, and the contention was that because you see like majority of the home buyers have given their consent, and the builder too has given its consent, so hence whatever is the understanding, if that is approved by the Honorable Court of Law, so thereafter that will become binding on each and every one, whosoever are concerned with the matter, and that will be the end of the matter. But counter argument was that there is a prescribed procedure under Section 12A which requires that the matter should be referred to COC for its approval, and the approval has to be with 90% of the voting rights. So Supreme Court, considering the facts and circumstances of the case, held that Section 12A, and in particular this Rule 30, capital A, is not mandatory in nature, it's only directory in nature, meaning thereby that if this particular rule is not followed, keeping in view the circumstances, then that won't be considered as violation, and everything done otherwise, that will be all illegal and violative of the rules and regulations. So in this particular matter, Supreme Court invoked its powers vested in Article 142 of the Constitution, extraordinary powers. Supreme Court decided that there is no need to refer the matter to COC and seek its approval with 90% voting rights and all that. And the matter was decided by Honorable Supreme Court that keeping in view the interest of 82 buyers out of 182 overall number of buyers, it would be something judicious and in the interest of home buyers to accept whatever settlement has been reached. And so what I mean to say, it's not necessary that if the application is to be withdrawn, it has to be it can be withdrawn only after following whatever is the due process of law. Supreme Court can make some aberrations, and at the same time powers have been vested with NCLT as well, under Rule 11 of NCLT rules, to make aberrations wherever the circumstances warrant. Thank you so much.